speaker today will be Michael Moore, who serves as the Senior Vice Provost and Dean of Undergraduate Studies. In 2010, he oversaw the opening of University College, a one-stop shop designed to provide a supportive environment that fosters academic success. Dr. Moore also has additional responsibilities for the Center for Distance Education and Classroom Support Services. In July of 2012, Moore received the Michael K. Moore Award for Research and Writing in the area of defense. This award was created to recognize 15 years of service on the Committee on Legal Services to the Poor in Criminal Matters, during which he worked without compensation to produce pivotal research and writing that helped provide low-income residents in Texas with proper legal representation. Today, he will be talking about the Fair Defense Act, as this would indicate. Without further ado, I would like to introduce Michael Moore.
Thank you for coming out today with this background noise that I've arranged for this cerebral conversation. I'd like to begin with just some acknowledgements and some caveats, I think. First, the acknowledgements. I've been doing this work, not so much in the last couple of years, but for about 15 years I've worked, as was mentioned, with the State Bar of Texas. And I really need to acknowledge the support my department gave me to allow me to do that, the time, to be able to spend, take time to drive down to Austin several times for meetings. And then even when I transferred over into the provost office, to also have the ability to continue to do that, because that day job is actually pretty demanding, and to have the understanding and the support of multiple provosts that I've worked with over the years to continue to allow me to do this work. It's easily been the most rewarding work that I've done in my professional career, in part because I think it made a difference, and that's what I hope to talk about today. Those of us that are in the academic enterprise here in the room can maybe count on one hand sometimes the number of citations or people we know that have actually read the stuff that's in our professional journals, and we wonder whether or not it's actually been looked at. The work we did here was very important, and that's the other thing I want to mention here is, by way of full disclosure, this is really not about me. Having that award named for me, excuse me, is terribly humbling. Was completely unexpected. And the best news somebody told me was that the good news was I didn't have to die in order to have it happen. Because normally when something's named for you, it's posthumously. So that's really good news. But it really is about a whole group of people that really contributed to the passage of the Fair Defense Act. And really what I thought I would do today and was asked to do is talk about really this journey to pass the Fair Defense Act, and now that it's been in place for a number of years, to maybe step back and look what's happened. And as it was mentioned, I served on the committee for 15 years. I no longer work on it. It's been a couple of years since I've been heavily involved in the work of the committee. And it was actually refreshing over the past couple of days to sort of step back and sort of refresh my memory about where we were when we started this conversation 17, 18 years ago, and really to see what's happening in the state of Texas now in regards to this topic. I can tell you when we began, this was not a topic that received any conversation. It was not even on the radar screen. And that's hopefully what I'll do today, is to talk a little bit about that. Full disclosure, I'm not a lawyer. So if you want to have lots of questions about case law, I'm not the right person to ask that. And I also want to offer this very important observation, that most of the people that are involved in our judicial system are good actors. The prosecutors, the judges, and the defense lawyers really are good actors. The overwhelming majority of them are very good actors, but not all of them. And that's the ones that those are the ones we have to guard against because of the potential damage that can be done. There's a principle that folks in the legal community know far better than I do. It's taken from William Blackstone, the famous English jurist, that talks essentially that it's better to let 10 guilty go free than have a single innocent person suffer. And when I started getting involved in this, I really didn't fully appreciate the nature of the people that we were asked to work on behalf of, but they truly are the voices. And it's not hard once you start thinking about the nature of this topic about why politicians don't particularly care about them. They don't vote. They're indigent. They're poor. They don't have any money. They're not contributing to campaigns. I've watched all 4 presidential debates. It hasn't come up once on the national situation about how might we better improve the quality of justice in this country. Not once, because the people that have the means have representation, and those that don't. And so I'm going to have to toggle back and forth here a little bit between the computer here.
Sorry.
So as long as I don't trip on something. Okay, that was you, not me. So I thought I might begin with a little bit of a discussion about, just very quickly here, about what is Texas justice? What are our images of Texas justice? And this is the first one that came to mind. Oh, wait a minute, I have a more updated image of Texas justice. So let me talk about Texas justice here just a little bit. We have in this state a very much a tough on crime sort of approach to our justice system. And let me just read some relevant statistics here. We lead the nations, and have for several years in a row, in the number of people that we strap to a gurney in terms of executions. Were Harris County, Houston, its own state, it would rank 3rd in the nation. Think about that for a second. Harris County, the one county alone, that for the longest time there, the district attorney down there, John Holmes, every case that was eligible for the death penalty was sent to a jury for the death penalty. Very different decision-making process happens in Harris County than it does in the rest of the state. In the rest of the state, the district attorneys tend to look at the severity of the crime, the cost involved, because these trials are typically terribly expensive to litigate. They're horribly complicated, the appellate process, but not in Harris County. If you committed a capital offense in Harris County, it was automatically going to be charged with death penalty. His view was just, we'll let the jury decide whether or not it merits the death penalty. And so death row is overwhelmingly populated by people from Harris County. Texas has the 4th highest rate of incarceration per capita in the country. And this tough on crime approach, though, may not necessarily yield the results that we think. We rank 13th in the nation in terms of violent crime per capita. So we're very tough on crime, but it doesn't necessarily have the deterrent effects that we might think. But there's some other things that we should know about our justice system here in the state of Texas. And these are current observations, not so much what was happening back when our committee started this work. We also lead the nation in exonerations. Dallas County alone leads the nation in exonerations based on DNA evidence. These are death row inmates, most of them. Some of them not death row, but most of them. Now, there's a positive to that story. A part of the reason why they lead the nation is because the district attorney, Craig Watkins, is aggressively looking into the matter. So there's both upsides and downsides. They're number one because they're looking into it, but the fact that there's that many wrongful convictions over there. And they're only looking at, obviously, the ones, too, that have DNA evidence attached to them. If one extrapolates that the system was flawed enough to convict these people in these high-profile cases where there was now DNA evidence, imagine what's happened in cases, the volume that would be there, rather, in cases that don't have DNA evidence that we can't look at. The system is that flawed. And if you have done any reading on what it used to be like in Dallas County under the district attorney, Harry Wade, it's just appalling the way that he advised his prosecutors to select jurors, the influence of racial bias. It's just absolutely appalling. We're a state where we have drawn national attention because the crime labs, particularly the crime lab in Harris County again, there we go, Houston, is tremendously flawed. They have had 6 crime investigators come forward in the last few years and swear under oath that they do not have the proper training to analyze blood samples. And this has affected hundreds and hundreds of cases. And they testified in those cases, and they're having to be re-examined. We're a state, as we'll talk about in a moment, where it's not a problem if the lawyer that you have in a death penalty trial sleeps. In a nearby county, Collin County, it's not a problem if your judge in the death penalty trial is having an affair with the prosecutor in that trial while that trial is going on. That apparently is not a problem either, unless, of course, you're the defendant, and then you end up here. It's a state where the presiding judge of the Court of Criminal Appeals, knowing that a last-minute appeal was coming to their desk on a death penalty matter, and the lawyers were having technical problems getting the thing out of the computer, shut the door at 5 o'clock and refused to receive the appeal. The because apparently she had to get home for dinner or something like that. It's also a state where the governor has openly interfered in the investigation of a innocence case, the Cameron Todd Willingham case, where there was an innocence commission appointed essentially to look into the matter. And instead of remaining silent, which would have probably been the appropriate thing to do while the folks deliberated on it and investigated it, he openly comments on it during the course of their deliberations, and really, by the view of most people, taints the outcome of that investigation through the appointments and people that he put in charge of chairing that committee, and just having it drag on till well after he was up for re-election. So we've got tough on crime, but we've also got a system with a fair amount of flaws. Before I get to my stories, I thought we might spend a little bit of time talking about what we might think of as some principles of a good or an ideal legal representation system. And for my colleagues in the room from the political science department, this is a well-known quote from one of the most famous court cases in our country's history, Gideon versus Wainwright, that established the right to an attorney. And actually Texas, interestingly enough, was well ahead of the nation. We had, at least on our books in Texas, the right to counsel dating back to the mid-1800s. And it wasn't until the Supreme Court came along much later than that in Gideon versus Wainwright there. But it's worth, let me just read it. The last thing you're supposed to do as a teacher is read to the class, but I think it's an important quote. It says, "In our adversarial system of criminal justice, any person hauled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him or her. This seems to us to be an obvious truth. Governments, both state and federal, quite properly spend vast sums of money to establish machinery to try defendants accused of crime. That governments hire lawyers to prosecute and defendants who have the money hire lawyers to defend are the strongest indications of the widespread belief that lawyers in the criminal courts are necessities, not luxuries." And of course, this is, if you Henry Fonda fan, you've seen the movie, and it's a wonderful, wonderful book. And I abused the title of this court case many times in the papers I wrote with various puns on muting Gideon's trumpet or the fading of Gideon's trumpet. However I could use that in a title, I did. I didn't do that today, and so forth. But from that, we might suggest the following, that these would be principles of a legal system that would provide good legal representation. Let me just spend a little bit of time talking on these, because this is how the Committee on Legal Services to the Poor sort of approached their matter, and that was to talk about how assignment might occur. So the defendant has been arrested, they're brought into the judicial system, and now the courts have to decide how we might assign those judges, rather the lawyers to those cases, and they can occur in Texas and really across the nation in really three ways. There's sort of an ad hoc system where and I'll talk about this in more detail in a moment, but the judge picks a lawyer through various means, and it was very much ad hoc initially. Another way is through public defender's offices. You may see those on television. That's how they're typically represented. The people assigned, it's the PD's office that's called in to represent the indigent. And in some cases, it's actually a contract system. In the same way that we would purchase a bridge, we get a contract, hire a firm or a group of lawyers who will agree to take on all the indigents that are needing representation, along with all the warts that go along with that. But these assignments you would hope that these lawyers that would do this would be competent, that they would be skilled at what they're doing, that they would be given the incentives to provide a vigorous defense, that wouldn't be simply about moving the cases along, that they would be appropriately compensated. And you would hope that they would be assigned in a manner that was fairly timely, within a day or a few hours, certainly not weeks and months, as was the case in Texas for a long time. You'd hope that the counsel would have the incentive to provide the best defense in terms of access to resources, experts, DNA experts, ballistics experts, psychological experts. The prosecution has access to those resources, so you'd hope that the defendants would have access to that as well. You'd hope that the system would be void of political considerations, that it wouldn't matter whether or not you contributed to the judge's campaign or not as to whether or not you got assigned, so that the politics were sort of removed from this. We like to talk about justice being blind. It's not always blind. And we'd also, I think, ultimately hope that this last thing happened, and that is that indigent defendants would have access to the same quality of justice as those that could afford attorneys, that the outcomes of our judicial system shouldn't be predicated based on whether or not you have money. If you have some leisurely time, go to the Texas Department of Corrections, look at their page for death row inmates and see if you can find all the millionaires on their page. It'll be a long search. Folks like O.J. Simpson that don't have a lot of money end up on death row. Folks like O.J. Simpson that have a lot of money don't end up on death row. The system very much does take into account your financial resources. But those would be good principles that we strive for. And it's where the committee that was formed, and the committee I keep referring to, was composed of really three groups of people. They had about a third of the people on there were judges, about a third of the people on the committee were prosecutors, and a third of the people on there were defense lawyers. And then initially I was not a member of the committee, I was an advisory member, and eventually I was added as a public member. It's a committee of about 50 people, and during my time on the committee there was a total of 2 public members on the committee, so at most the public represented had folks like you and I, non-lawyers, had just 2 votes on there. And ironically, we were the ones frequently sort of championing the cause of the committee, sort of pushing the cause. It's almost as if the committee was reluctant to act. Since we're in a library, I thought about how we might best approach examining how the Fair Defense Acts got passed. I thought we might start by telling some stories. We have lots of books here in the library with lots of stories in it. And so the first story I want to tell is entitled this: The Deafening Silence, the Story of the State Bar of Texas. I should begin with a little bit of background about how I came to be on the committee. And a very good friend of mine, who some of you know, a dear colleague of ours in the department, Professor Emeritus Alan Butcher, who had been a criminal defense attorney in the state here for a very, very long time, taught for us for a number of years, teaching criminal law classes, had been asked to be the founding chair of the Committee on Legal Services of the Poor and Criminal Matters. The State Bar, for a very long time, had a committee on civil matters, and they were sort of pressured by their leadership to create one on criminal matters, and they did so, and Alan was asked to chair that. At one time, he was probably the most respected appellate lawyer in the state. He's argued before the U.S. Supreme Court and had a number of death penalty cases at the appellate stage. He's very well respected in the legal communities, and he was asked to chair this committee. And they'd been meeting for about a year on sort of a quarterly basis, and at these meetings they got together and they sort of wrung their hands a little bit, and they told war stories about the horrible things that were happening in the courts. And they came to the conclusion that they really didn't have any systematic evidence on which to proceed. They knew the changes needed to happen, but it was just one lawyer's story out of one courtroom about how horrible their experience was, and a prosecutor in the room saying it's not nearly as bad as you think it is, and the judge saying there's no problems in my court. It just was these series of stories. So over coffee one morning, Alan asked me if I would be willing to attend a single meeting with him to listen to what the committee might say about how I might be able to help them. And I was an assistant professor, hadn't been here at UTA very long, and knowing that one of the things that was critical to getting tenure was service, it's one of those boxes we have to check, I needed some service that I needed to do, and I thought this might fall into that category of doing service. So I agreed to go with Alan. He promised he'd buy me breakfast, it would be a good time. So we got up at crack of dawn, 4 a.m., drove down there, stopped and had breakfast along the way, and found out by the end of the meeting, by the time I came home, that I had been talked into helping them conduct a statewide survey of all the criminal defense lawyers. So we spent the next several months designing that survey, and then over the course of a couple of years, we began to collect data systematically from first criminal defense lawyers in the state, then the prosecutors in the state, and then the judges in the state. And so the first story I want to tell is in that context. After a while, I was invited to be a member of the committee. I think they did that because if I was a member of the committee, I wouldn't be able to bill them for all the hours that I was assuming that's what outside consultants would have been able to do. The State Bar, when we began working on this, and I started sort of surveying the landscape among other state bars across the country, we started attending national meetings to learn about the topic and so forth. And we found that in many states, the State Bar was the champion. They would latch onto this issue. There would be a highly respected lawyer, frequently a lawyer from the civil side, some big highbrow firm that agreed to take on, that's what happens in a lot of places. They take on the high-profile death penalty case. They take one of their, multi-$100 an hour lawyers, and they assign them to represent this case pro bono, and that's their, contribution to society and so forth. And these firms typically became the advocates and the champions, and the bar in those states really became the advocates. And I really have never delved into this. I don't know if it's so much because we have so many executions in the state, it's such part of our culture, but the bar in Texas has absolutely no appetite whatsoever for that advocacy. And the story that I'm going to tell here really over the next few minutes about how we got to the Fair Defense Act is a very familiar one to my colleagues in the political science department about how bills become laws. It's about the convergence of multiple factors coming together, and it's really not so much the idea that you have the best idea about how to solve a problem. It's just sometimes events tend to come together. So what we did over the course of these months was we gathered together lots of evidence, and this may be too small to see up there. Actually, it's maybe too bad they're in the back. But I just want to give you an example of some of the data that we were gathering from. This was from a judge's survey. We asked them that when you're thinking about the factors that influence how you make an appointment, again, going back to this competency notion and so forth, what are the factors that you consider? And I've highlighted here a few to maybe make it a little easier to draw your attention to. The first one, difficulty of the case. This is good news here. 80% of the judges responded that the complexity of the case is a factor that they consider. If it's a really complicated, say a death penalty matter, or complicated crime of passion, or whatever it might be, they take that into consideration. A little more troubling, though, down here are some of the following responses. The next one I have in here. The attorney's reputation for moving the case regardless of the quality of the defense. 31% of the judges indicate that is a factor that they consider. It's not the majority response, it's not the most common response, but it's a troubling response, I would think. That 31% of the judges responded that speed, essentially, regardless of the quality of the defense, is a factor. 29% considered whether or not the person was a political supporter or not. A quarter said whether or not they contributed to their campaign. Now, interestingly, a little side note here, these cut kind of both ways. There are some cases that are very straightforward, they're very easy, and in fact some courts have kind of attorney of the day. You show up and the judge will give you, a dozen cases, you plead those things out, you make a little bit of money on them, you turn it in, it's been a good day's work, okay? But we also learned from the comments from defense attorneys that you could sort of get screwed in this process as well. If you had been solicited by the judge for a campaign contribution and you had not contributed to the campaign, they gave you very difficult, complicated cases for you to handle. You've been appointed by the judge. You don't get to decline. You say, no, sorry, judge, I don't want to do this. You've been assigned. You now have to do this. You might get a death penalty case in which it's going to take you the entire year to investigate this and litigate this in an appropriate manner. And the judge controls whether or not you get paid and how much you get paid. And they could literally wreck an individual's practice. Most criminal defense attorneys are not what you see on television in these nice tall office towers with multiple clerks working for them and large libraries and so forth. Most criminal defense lawyers are sole practitioners. I think the folks in the political science department, if we had a message for all of our students that want to head off to law school, so that's what we see on television, right, or the criminal defense, those are the exciting ones on. LA Law that used to be on, and CSIs and all these things, these complicated law and orders. Those lawyers are poor. There's a lot of very poor criminal defense attorneys in the state. There's a lot of unemployed criminal defense attorneys in the state. And the notion that, so this is not, if they're supporting me, I'll throw them a bone and let them get some money. These were often cases where the judge was vindictive in their decision on how to appoint somebody. Very, very disturbing results. Again, this is all prior to the Fair Defense Act. We asked all three of them here, so the blue bars, these are the bars representing defense lawyers, the other ones are the prosecutors and the judges. We asked the question whether or not we felt that you received better representation from court-appointed attorneys or retained. There's a real divergence of opinion here. The prosecutors think that everything is just the same, and I'll come back to that in just a moment here. Defense attorneys, 70% of them say that the representation provided by retained counsel is better than the representation provided by appointed counsel. And I need to make an important observation here about that. The way the lawyers are assigned in Texas is this is the same pool of people. It's not that there's a pool of appointed people over here doing only appointed work, and there's another pool over here doing only retained work. These are the same lawyers. It's the same pool. You may have one client that you've been assigned to by the judge because you happen to be in court that day, or you're on a list, or however they decided to do it, and then you've got other clients that are paying you. This is a very damning statistic because it says essentially that when this pool of lawyers represents appointed clients, they don't do the same quality of work as when they're being paid so forth. And even judges acknowledge, 40% of them, that the retained people usually do a better job. Okay. I'm picking some sort of selected questions from the large survey here. This was asked to prosecutors and judges. We asked them whether or not there was a difference in how the lawyers prepared when they were representing their retained or their assigned clients in terms of the amount of time they devoted, how well prepared, and whether or not they were putting on a vigorous defense. And you can see the numbers are pretty stunning, that they agree that they devote less time, they are less prepared, and they put on a less vigorous defense. Now it's interesting that prosecutors are saying this here, but on the prior question they said it didn't make any difference in terms of overall. To me, those are very incongruent kinds of representations. But where we ended up here with this was a picture overall that the system was very, very broken, that counsel were not being assigned in a timely manner. It was not unusual for folks to sit in jail on some misdemeanor charges, past the amount of time they would have been convicted to serve, awaiting for counsel to represent them. There are situations where the defendant would have to be forced into making the decision that I can afford to post bond to get out so I can go back to my job, so I can go back to my family. But if I do that, I'm not going to get a lawyer because the courts wouldn't assign lawyers. They made the assumption that if you can afford bond, you can afford a lawyer, and that's not true. Those are very different situations. And then we had this evidence that started to seem to sort of confirm these war stories that the lawyers were telling us, that we were getting lousy representation here. And so to go back to where I began, there are real consequences here in terms of the quality of representation, and then there's real people's lives at stake. So we assembled all this. We wrote a white paper. The committee did. We went through multiple drafts, and this is where the deafening silence from the state bar comes in. We decided that it was adopted after deliberations in the committee, and then we wanted to present it to the state bar leadership at their annual meetings in hopes that they would adopt the report and act on the recommendations, and then hopefully take this and turn it into legislative actions. Showing tremendous bravery, the state bar received our report. They wouldn't accept it. They didn't vote it down. They just acknowledged that they got it. That's all they did. We decided to try to get a little bit more attention, and so the committee decided, you know what, we need to bring some national attention to this. We're going to hold a national conference. We brought in folks that were at the ABA, folks that have been leading the charge on this, like Norm Lefstein and others. And the bar, we were hoping, would help underwrite the expense, for example, provide a meal, some coffee and cookies. This turned into a major brouhaha with the state bar, and took months for us to get them. We'd already made reservations for people to come. They said, no, you can't do this. We're not going to let you fund it anymore. Only at the last minute, after they got pressure sort of from the state legislature, some key legislators, did they finally pony up enough money for lunch, cookies, and coffee. But they never did. The bar never did become an advocate for this issue. They never did champion this cause. They never have backed the Fair Defense Act. The leadership has just remained silent on it. And I could be happy to talk about some reasons why I think that might be the case and some questions. So it's time for our second story. The value of a good nap. The story of Joe Frank Cannon and Calvin Burdine. This starts to paint the story, I think, of how you don't control the events you have. This is Calvin Burdine. Let me tell you a little bit about Mr. Burdine. So the work we began was really in the late 1990s and early 2000s. The report was received by the bar in 2000. Back in 1983, W.T. Wise was murdered at his home in Houston. I always have to say Houston. He was murdered. He was gay, and the two people that were arrested, one of them was his gay lover, Calvin Burdine, and another one was a guy named Douglas McCright. Mr. McCright pled to a lesser charge, was sentenced to 8 years, served 8 years. Burdine maintained the entire time that he was involved with the robbery, but he was not involved with the murder. And so he pled not guilty, and because we're in Houston, and it was now a capital crime, and the DA was John Holmes, they decided they had to submit this to a jury to determine whether or not this would be a capital offense. And so he was taken before a judge, and not surprisingly, given the slide I showed you a little earlier, the judge was looking for somebody that would move along the case very quickly, and they found Frank Joe Cannon, or Frank Joe Cannon. And Mr. Cannon had a reputation, a courthouse reputation in Houston for moving cases along very quickly. A trial began on January 23rd, and 4 days later it was completed. For those of you that know anything about death penalty trials in the state of Texas, that is light speed. These things, usually you spend far more time than that selecting the jury. Jury selection can take a couple of weeks. So the trial phase concludes in 4 days. The jury deliberates a total of 2.5 hours on this matter, and after they come back from their deliberations, the next phase in the death penalty trials is the punishment phase, to decide whether or not, so he's guilty, that's the first part, is it death now. His lawyer argued for 29 minutes for him to spare his life. This is where the lawyer gets the opportunity to raise mitigating factors, talk about childhood abuse or anything that might have been there. And so a total of 29 minutes. He was sentenced to death. That's not the remarkable part of the story. The remarkable part of the story is that during the trial, Mr. Cannon fell asleep 10 times, at least, according to the court record, for periods up to 10 minutes in length. That's remarkable, right? It gets worse. The judge didn't stop it. The judge saw it. So the judge doesn't intervene and stop the trial. The prosecutor doesn't do anything. They've all taken an oath to do justice, not to win. So the prosecutor's oath is to make sure that justice is done, not necessarily to win the case and so forth. The prosecutor is allowed to make the following statement during the punishment phase. He said, quote, "Sending a homosexual to the penitentiary certain isn't a very bad punishment for a homosexual, is it?" No objection from the defense. The defense attorney is asleep, so there's no objection, and the judge allows that comment to be made. You'd think it couldn't get much worse, but it does. There's an automatic appeal when somebody's convicted in a death penalty case, and in this case, that happened, and quite commonly another lawyer is assigned to deal with that, but in this case, the judge assigned Joe Cannon to deal with the appeal, and not surprisingly, the grounds were upheld. On the federal side, there's another appeal that happens on the federal side of the case, and in the first appeal that happened there in 2009, the judge in federal district court actually finally ruled that a sleeping lawyer was problematic. Now what's amazing about this initial trial is the state of Texas, the Attorney General's office, actually went to court and openly argued that a sleeping lawyer was okay. They consciously took this position. Think about that for a moment. State Attorney General's office, knowing what is happening, knowing what the argument is, ineffective assistance counsel, makes the decision to go to court and defend that a sleeping lawyer is okay. The judge said, no, that's not the case. The state of Texas decides to appeal this decision, that it's not okay. So it goes to the Fifth Circuit in New Orleans, and a 3-judge panel now hears this case, and they overturn the district decision that said it wasn't okay to sleep, and they affirm the the position that the State Attorney General's office has taken, that it is okay, that it's not necessarily ineffective assistance of counsel to have a sleeping lawyer. They ruled that that a sleeping lawyer was no worse than a lawyer who was drunk, a lawyer who had been under the influence of drugs, a lawyer who was suffering from Alzheimer's, or who was having a psychotic episode. And they had all previously held those kinds of lawyers to be appropriate.
What year was that, Michael?
That was in, I believe, 2000. Okay, early 2000. A lot of public scrutiny came down on that decision, and the court heard in what's called an en banc panel, which is where instead of a 3-judge panel, all the judges that are assigned to the Fifth Circuit heard it, and ultimately reversed that decision and ordered a new trial. But the vote was 9-5. So 5 judges in the en banc panel said it's okay for the lawyer to sleep. Burdine eventually was offered a life sentence and pled to life instead of on death row, so he got some relief on that. But the damage had been done by this point. Texas was nationally known now. This is now about 2000. At the same time the State Bar has received our report, they are now known as the state that has sleeping lawyers assigned to death penalty cases and has taken the political position that this is okay. They've taken the political position to legally argue to the court. Instead of saying, you're right, this is a bad deal, this guy deserves a new trial, let's do a new trial, they carried that on. So after 20 years on death row, Mr. Burdine was allowed to finish the rest of his life in prison in just regular confinement. My third and final story. Thank you, George Bush. For those who know me, this is really funny. My hero. Our final part of the story goes something like this. In 1999, during the 76th legislative session, Senator Ellis from Houston, you guys are good. Yeah. From Houston, everything's from Houston. He'd been a longtime champion of the rights of criminal defendants and so forth, and he introduced a bill that the bill number was Senate Bill 247, that sort of laid the groundwork, if you will, for the Fair Defense Act. It's pretty minimal. He put in some minimal qualifications for lawyers, so they need to reach a certain bar in terms of experience. He provided some incentives to allow counties to set up public defense offices. He put in some requirements in terms of how quickly the lawyer had to be assigned, a week in his case. The bill went through the House without objection. It passed unanimously. Imagine that in today's political climate. It passed the Senate unanimously, went to the governor's desk. This is now, the legislature had actually adjourned. They had done their work, so there's a stack of bills that's on the governor's desk, so it's waiting for signatures. Again, passed House and Senate unanimously. The 11th hour, a bunch of whispers come to the governor's ear, and Bush vetoes the bill. Remarkably, no one really knew why. I mean, why would you veto a bill that had unanimous support across the House and the Senate? And what we later learned is that a lot of judges sort of got to the governor's ear. They didn't like the fact that it was basically going to strip away the judge's discretion on how they could appoint counsel in cases, so the governor vetoed the bill. At the time he's vetoing the bill, he most likely has already made the decision that he is running for president of the United States, and this brought to Texas an amount of attention that was not welcome in some quarters. And this particular issue of the representation, the sleeping lawyer from Houston who is determined as competent, you kind of see these convergence of forces, if you will, brought national media attention. And about, again, same time period, our study has been received. It gets picked up in the Dallas Morning News on the front page of it. And there is a story that talks about the quality of legal representation in the state of Texas and the conclusions of it. ABC News happens to be that week down interviewing the governor, Sam Donaldson. We just had Kofi Roberts, his counterpart here on campus, and they asked him about the quality of representation and pull some quotes from our study. And this is my 15 seconds of national fame, my Andy Warhol moment. He says that the people of Texas disagree with Michael Moore. The governor's never met me, but felt honored to be quoted on ABC's national primetime broadcast. But what had happened by this point is that it created a climate that something had to be done. it was a national embarrassment that we had sleeping lawyers, that we had people sitting in jails longer than the length of their sentence before they got assigned counsel. It was just a horrible, horrible situation. And even though Bush is not there, his veto of Senate Bill 247 was actually the best thing that could have happened to indigent defense in the state of Texas. Because what happened in the next session, even though he's not the governor at that time, is Ellis comes back very early in the session, Senate Bill 7, notice the difference in the numbering, and introduces what became the Fair Defense Act. And the Fair Defense Act makes that first version of the bill look like child's play. It assigned lawyers within days, not weeks. It set qualifications for lawyers. It provided state funding for indigent defense and so forth. So the point I'm trying to make here, and then I'm going to get on here in just a moment here and talk quickly about some of the improvements. We made the case at the bar about what needed to be done. And if the bar had wanted to be a leader, this is the group of people that represents the judges, the lawyers, and the prosecutors in the state. If they want reform in the judicial system, they could probably get it because they have access to all the decision makers, and it's their playground. If they want to change it, if they could agree on it, they could probably get the change done. But they were silent on the matter. And it really wasn't so much the work of the committee as it really was, I owe a debt of thanks, we all owe a debt of thanks to a sleeping lawyer and to a veto decision by Governor Bush to make the decision to veto that legislation, because the Fair Defense Act wouldn't have happened without them. This is what the Fair Defense Act does, and I'm just going to go through this very quickly, and then I'll talk about some of the remaining challenges and how I think it's actually helped. It set professional standards. All counties were required to develop an indigent defense plan, and the plan has to dictate how lawyers are going to be assigned. It's no more of this, I want Mark to be the lawyer today because Mark is my friend and I got 20 cases to run through and he can make a good buck, and I'm going to give Blake this death penalty case because I can't stand Blake and he contributed much. None of that anymore. There is now a list, and you have to have qualifications on how to get onto this list, and counties can have different kinds of lists for misdemeanor kinds. I think lawyers have to apply to get on the list. There are rules that govern how the public defender systems are created and how contract systems are created as well. And this is perhaps the most important part of it here, is decisions about how quickly counsel has to be assigned. If it's a county less than 250,000 people, you only have 3 working days to assign a lawyer to the case. You can't wait until the arraignment has to be done after they come into custody. And if it's more than 250,000, you've got 1 business day in order to assign counsel. There is still some issue about whether or not you are entitled to, if you bond out. Counties are still really struggling with that, and I think that's one of the things that remains some trouble for counties to work on. They've had better definitions of what qualifies as being indigent. I'll skip the bullets there in the interest of time. And there's now fee schedules so that the lawyer knows how much money to be expected to be paid, instead of it being at the whim of the judge to compensate the lawyer whether or not they like the work. Judges, for example, we heard lots of reports of this where if I'm the judge and Carl is the assigned counsel, and I think this case ought to be moving through pretty liquidly split, and Carl decides to get obstinate and say, you know, I need a ballistics person. I want to do an IQ test on the mental health of my client, and I think you're delaying the process. I'd cut Carl's pay. That was my leverage on Carl. So you wouldn't ask for those kinds of services because you needed your pay in order, which wasn't enough. That kind of stuff has all been cleaned up. There's better access to support services now, and there's actually monitoring going on at the counties and their services and so forth. The law went into effect in 2001, and starting in 2003, the committee decided to take a look at whether or not we thought this law was making a difference. So we first did prosecutors, and then we did it again, or defense lawyers, and then we did it again with prosecutors. Again, probably small print there at the back. Just a few select questions. Does your county publish standards? Now, what we had is kind of a question. These are charts that compare the knowledge before and after the Fair Defense Act. You can see it went from 35% up to 85%, so there's greater knowledge that there are standards. Does the judge use a similar method? Attorneys reporting from 41 to 62, it increased consistency in how appointments were made. They have an established list down here. So this is all just evidence pointing that the law was having some of the desired effect, which was to increase awareness about the way things ought to operate. Do you have a fee schedule? There was a little bit of an increase there. Not much improvement here on this last question, which about whether or not there was enough compensation to attract qualified attorneys or not. There's still a lot of complaints that it's very low. These are important questions, I think. Since the implementation, do you believe the time has gone, committed by the defense counsel has been improved? Defense attorneys report nearly 30% that they either greatly or somewhat increased the amount of time that's been spent on those cases. They also report down here about 20% that there's been an increase in the vigorous defense provided to those divided. 33%, if you take the top two categories for attorneys, are reporting that they believe that the quality of representation has improved. And this question to me was very interesting, and asked them personally whether or not they were doing a better job. So it's one thing to sort of reflect on your colleagues and say, yeah, Mark used to do a lousy job, but he's doing better now that he's getting some pay. This question says about me, you know, am I doing a better job? And there's some evidence here, not dramatic, but some evidence indicating that the quality of representation has gotten a little better here. Overall, do you think that the quality of representation since the passage of the Fair Defense Act has improved? Again, this is just a couple of years after the survey was done, about a 36% increase there. 10 years later, this was sort of the retrospective that I was able to take in looking back. There has been tremendous change in the state of Texas in terms of how indigent representation is provided. Actually, this was a very pleasant surprise. We're now spending about $33 million that's coming out of the state money. It's not nearly enough to fund the entire thing. That's being distributed in terms of formula grants that sort of goes automatically to the counties, and then there's also some funds that are distributed in terms of competitive grants for special projects. The state, through the commission that they've established, the Texas Indigent Defense Commission, is now partnered with Texas A&M University to monitor the activities that are occurring in the various counties. In fact, this week they just released a big study of Weiss County's Public Defender's Office. So this is remarkable if you think where we've come in a decade, that the state of Texas is now actually investigating the quality of defense that is happening in counties and where we were prior to that. What was a temporary task force has now been institutionalized. It's now the Texas Indigent Defense Commission. They're the ones that are leading this. They have for 8 years in a row now been conducting workshops to help attorneys get better. They've led a couple of national summits and so forth. They are the ones that have published this primer that's given to lawyers about what the Fair Defense Act is like. We have a wrongful commissions panel. Think of this like a national transportation board that investigates a train accident. When there's evidence that a case has gone wrong, they go in and look at where did it go wrong so they can maybe find adjustments to the system. With the exception of this last bullet point, none of this has been led by the state bar. None of this. The people that theoretically have the most at stake in the system, the judges, the prosecutors, and lawyers, this is all being done by external people appointed to these commissions, and most of it by this. The state bar finally did get around to adopting performance standards for attorneys, and this is I think my last story that I want to tell you sort of before wrapping this up, and I'll tell you how we got to this. One of the last efforts that I was able to work on while I was at the committee was, once we'd gotten the Fair Defense Act sort of adopted, we thought, well, what can we do next? We had evidence that lawyers in habeas appeals were focused mostly on death penalty because it was such a serious issue, obviously, when somebody's life's at stake. They were literally cutting and pasting from one brief they had submitted on behalf of one defendant and cutting and pasting it to the brief on behalf of another defendant. Those of us that are faculty who accept this behavior from our students in our classroom, let alone a death penalty matter that's on appeal before a court. And in some instances, the facts are wrong, right? Because part of what you do in the brief is you describe what happened in the crime. They would cut and paste the facts from this and drop it in another defendant's brief and submit that to the court, and it's completely wrong. We tried, the committee tried, to get the bar to take these lawyers up before their disciplinary panel. There is a process by which to do that. And this will stun you, I'm sure. The bar refused. They did not feel that these things warranted disciplinary. So this was sort of the benign way to go about it. We wrote some general guidelines about what are appropriate things you need to do, like you need to meet with your client, you need to know the facts of the case, you need to, these are the kinds of things, these are the kinds of bullet points. The bar did adopt those. They did adopt them instead of just receive them, but they did adopt them and so forth. I'm going to highlight just a couple of these and then I'm going to stop in the interest of time. There's a lot of work to be done. I'll come back to the slide at the very end. I want to talk specifically about just a couple of these that are really, really easy to do. The two greatest sources of wrongful convictions are misidentification in lineups and false confessions. And these are in my opinion, two of the easiest things to fix, and it just takes some political courage to do it and the willingness. First, let's talk about lineups. We've all seen how it's done on television, right? They run the defendants out there, they're all holding a little number, and they bring the person to the window that can't be seen, and the cop is there, and also the other person's, the lawyer perhaps for somebody's there, asking whether or not they can identify. There's all kinds of stuff that's wrong with that. First thing that's wrong with that is that the police officer doing the investigation is the one conducting the lineup. And they tend to, studies have found, steer the witness to make a decision that somebody's up there. The other thing is there's an assumption, because there are 6 people out there, that one of those is the person and I have to pick somebody. That also leads to a lot of wrongful false identifications. Solution is really simple. And some jurisdictions have done this, Texas has not. You do 2 things. You don't let the people conducting the lineups have anything to do with the investigation. You just assign somebody to run lineups, that's what they do. They know nothing about what's going on in the investigation. That's what their job is to put together a lineup. And the second thing you do is you present the suspects in a completely different manner. You present them one at a time, and you don't tell the witness how many they're going to see. You might see 1, you might see 3, you might see 5, you might see 12. And the studies have shown that these 2 simple changes remove false identifications. And the reason this is such an important change to make is think about the power of eyewitness testimony when you get to a courtroom and now somebody has said the witness identified so-and-so as the person doing it. Fix these 2 things, it's almost a no-cost solution, and it would drastically improve it. The other one are the false confessions, and this is one that the public has a real hard time understanding. Why in the world would anybody confess to something they didn't do? I used to have a hard time understanding this as well until I saw some tapes of how this actually happens and the amount of coercion that can happen by well-meaning police officers sometimes not so well-meaning police officers. The way they can coerce a defendant to confess to something either out of fear or because the person has mental retardation issues or because they have some fatigue issues. A real quick story. Van hits, a man is drunk, he and his wife have been fighting. They pull over the van, she gets out, decides to walk, he drives off. She's later found dead by the side of the road. They learn from people that were at the party with him that they'd had a fight, that he'd been drinking. They tell him during the course of this very, very long, protracted investigation that they know he did it. There's blood on the bumper, there's fur on rather hair on the bumper. They know that this was happening. I've already took my story here. He confesses. Turns out he hit a deer weeks before, and the blood was from a deer, and the hair was from a deer. His wife had truly been hit by the side of the road, but he didn't do it. It was another driver. But he confessed because he hadn't been presented with the correct information. The simple way to do these sorts of things, and you get at some of that. I mean, they went at this guy for hours and hours and hours with a good cop, bad cop, whole thing. We tape and record the confession. That's standard practice. And this is not expensive technology. We're using it in every courthouse and every jail cell around the country. Just tape the whole thing. Just record the entire conversation, the entire interrogation, and make it available for the defense attorneys. It actually ends up being a protection for the police in the long run because they can't be accused of misconduct. I'll talk about some of these other ones if you want. My last one here would be vote. It's really hard as a political scientist for me to convince you to go vote in this presidential election because in Texas your vote doesn't matter. It's irrelevant. We're a red state. It's not going to matter. But there is a very, very important race for the Court of Criminal Appeals right now for the presiding judge, Sharon Keller, and she's vulnerable for the first time in her history. And Keith Hampton is running against her. He's been endorsed by most legal organizations in the state. He's on this side of these issues. He's out of the Houston area, out of their law school, and works on the Innocence Project. So if you're looking for a reason to go vote and the presidential election doesn't inspire you, maybe the election for the Court of Criminal Appeals will. So I will stop there and take any questions you might have. Sorry if I went on just a few minutes too long. Yes, sir.
What about the assignment of counsel in the questioning phase?
In the questioning phase, I mean, when they're...
Just the first arrest.
Well, in theory, that happens now much better than it used to, because they have to, so in the counties we're familiar with, Tarrant, they have to assign counsel in 24 hours. Now, there obviously is some obligation on the part of the defendant to have sense about them, to not talk during that initial 24 hours to the lawyer gets there. That's why myself and others would like to see the recording of the entire custodial interrogation, so that if the questioning began before the lawyer was appointed, there is a record of it. Right now, there's no record. What frequently happens is they arrest you, we question you, we intimidate you, you confess, and by the time the lawyer gets on the case, you've already confessed and it's too late. If we had the entire custodial conversation recorded, the defendant would be in a better position. Carl.
I was astonished to see the data that you showed about judges appointing prosecutors based on whether or not they could.
Makes your stomach turn in some respects.
And I shouldn't have been surprised to see that. I'm hoping that there has been a movement for some time to get judges appointed by some other way than the election in the state. Please tell me that there is.
Yeah, well, I've got colleagues here that know far more about this than I do, but I mean no system's perfect, right? Because the alternative, there's three systems of picking judges in this country. One is elections with all its warts. Here it's not as bad as it is. Some places it's partisan, as though there's a Republican form of, which is what we have, right? You've got Republican justice and Democratic justice. Some states do nonpartisan elections. There's the appointment process, which you simply give the governor the power to appoint, which has another set of political problems with it. And then there's the system that's usually run out there, which is not a whole lot better, I don't think. I think we all think there's probably, it's called the merit system. Sometimes it goes by the Missouri plan, which is where there's an appointment by the governor for a period, and then the judge stands for election on what's called a retention ballot. Should Carl be retained as judge of the 101st Court, yes or no? So you're not running against an opponent, you're running against no. And unless you've done something horrific to get the public's attention, the re-election rate in those is off the charts. It is a problem. Some reforms that would help would be not allowing members of the bar to be solicited by the judges. I mean, think about the conflict. I mean, I've seen some of these letters. They're not very subtle. The judge sends a letter to all the lawyers that are working in his or her court asking for contributions, sometimes with a very overt claim that you'll get your money back through appointments. So give me $1,000, I'll make sure you get that money back. So it's not going to cost you. You'll get that money back. It's a problem. And it gets talked about in Texas from time to time. Somebody will write an editorial, but it never goes into work.
I want to give you sincere, humble praise for your passion.
Thank you.
I suppose you've run into Jim Harrington over the years.
Oh, yeah.
Awesome. I can personally testify to everyone in this room of knowing judges and the attorneys. And there is one attorney in Arlington, another one in Arlington and Dallas. If they went to school with the judge, and or the amount of, as what was it, Oliver Wendell Holmes said, justice has nothing to do with the truth, only with the fair due process, if I got that quote right. But one attorney is famous for saying she has more convicts on death row here in Texas than any other. But I guarantee if she would walk up to that particular judge she went to law school with, and this young man had 2 DWIs within 6 months, and he got off for 6 months probation.
It matters.
Now, I will
There
fess to
are a
having-
number of people on death row.
Yeah, I will fess to having enabled a few of those situations, which I no longer do, but I could go on.
Yeah.
One who's argued before the U.S. Supreme Court on civil rights, you can begin to guess who I'm talking about, and it's who you know.
Yep.
And or if you have more skeletons than J. Edgar Hoover.
Thank you. I'm getting the time signal back there, so that means
One more
refreshments,
question.
right? One more question, you think? Yes, ma'am.
Yeah, you had said that when you were talking about the state bar, and that you might mention to us a little bit more background on why it was that they were so reluctant. I'd love to hear that, and I was also curious, just, sounds like, I don't know very much about the state bar specifically, but I'd love if you could talk to us a little bit about, what are some of the accountability, is there any kind of accountability for members of the state bar? Who are
So-
these people, how do they get in the?
So one difference between our state and other states is we're a closed shop. Every lawyer that has a bar card has to be one. It's not true in other states. They're all licensed in other states, but joining the bar association is a voluntary activity. And I suspect, I haven't tested it or anything, I suspect what you would find is that there's a greater propensity to feel like they can be advocates and take positions if it's a voluntary association. You don't like what we're doing, you don't have to join, you don't have to pay your dues. So I think by not having that option here, they tend to be very, very conservative. And they don't want to do anything that upsets any of their constituency. And they are heavily influenced by the judges, was the sort of my observation over the years. And they were the ones that had the defendants had the most to lose, would take them out of, some people wondered, why didn't you survey defendants? There was a whole other issue about sending surveys to jails and things like that. But of the three actors in the system, judges had the most to lose by the implementation of the Fair Defense Act because they lost their discretion on how they appointed people. They are the ones that are responsible for the budgets of the court, and they saw this as causing the budget to rise because they're going to have to pay people more, they're going to have to pay for experts and so forth. So the judges were very, very much opposed to this legislation. Hence the veto of the first bill in the whisper to Bush's ear, even though it passed unanimously. So those are my two sort of operating theories, that they don't want to upset the judges and it's a closed shop. So, thank you very much for coming out.